Good morning. We are now moving into the material in Note 5, and we are actually getting to the substantive materials that make up the bulk of this course. We will deal in Note 5 with partnerships and limited partnerships, limited liability partnerships as well, and we'll have a discussion as to what a partnership is and what it means. But we are now moving into one of the business entity types that has been used for hundreds of years and has become less common today as corporate structures have evolved and have become simpler and have taken over. But there are still many entities that operate within the United States that are partnerships in the pure sense of the word as that applied at common law several hundred years ago. The definition of a partnership is an association of two or more persons to carry on as co-owners of a business for profit. There are certain elements we look for to determine if a situation is a partnership or not. Now, for those of you who haven't heard the word element before, we lawyers like to take definitions and break them down into their component parts, break them down into little chunks, little segments, partly for better understanding, partly for clarity, partly to have kind of a sharpness in the definition, to know exactly what it is we're talking about by having exact words and exact ideas apply. If you've ever studied criminal law, you know that at common law, there were elements of each crime, so that if you wanted to prove that somebody was guilty of a common law crime, you had to look at the basic building blocks, the elements the judges had laid out that said this is what it constitutes a crime, and you had to bring in competent evidence beyond a reasonable doubt on each one of those elements. And if you missed one of them, then your criminal case, your prosecution would fail. One of my favorites is burglary. The common law definition of burglary was, number one, the breaking and entering. Number two, into the dwelling place of another. Number three, at night. Number four, with the intent to commit a felony therein. So you had those elements, and you had to prove information on each one of them, or your case would be dismissed. There would be no judgment of prosecution, no judgment of guilt. So if a prosecutor under the common law courts forgot to state that, oh yes, this burglary happened at night, Your Honor, after sundown, then the case would be thrown out. Now, going back to our present-day business law, the elements of a partnership are that there are a sharing of the profits and the loss by the partners, that there is joint ownership, recognized joint ownership of the business itself and of whatever assets are owned by the business, and that there are, if not equal, there are at least participatory rights to manage and control the partnership by everyone who is calling themselves or deemed to be a partner. Now, at common law, a partnership was not really an entity separate from the individuals. Liability applied to the individuals, not to the entity, and that's still true today for general partnerships, regular partnerships. And the partnerships could not own property as partners. As a partnership, every partner had to have their name on the property. Every partner had to sign off. Every partner had to be part of a decision to sell. In suing, partnerships did not exist. Partners were deemed to be jointly liable, which meant that each and every one of them was responsible, which sounds like, oh, that's good. We have more people to sue, more people from whom we can get a recovery. However, the other side of that is you had to get good service of process on every one of the partners, or you had no case. You couldn't bring a case against the partnership itself, or you couldn't bring a case against one or two. That is called joint liability, and in joint liability, you must join. You must bring together everyone involved in order to go forward on a lawsuit. Now, today, under the Uniform Partnership Act, you no longer have to sue every partner. There is no longer just joint liability. We have now what we call joint and several liability. Joint meaning, yes, everybody could be held responsible. Several meaning that we can sever, we can break it up, and we can bring a separate lawsuit against each of the individual partners. If we can't find all of them at once today, we can sue the two that we found, and at a later point we can bring in, or we can sue the third one that's out of the jurisdiction or who's not, we haven't been able to serve. We can also, under the Uniform Partnership Act, the partnership itself is an entity and can be sued and named in court as an entity without having to individually serve each partner. And the partnership can own property in its name, can hold title to property in its name. And when it comes time to sell, it would only take the action of one partner acting as an agent of the partnership to effectuate the sale. So we wouldn't have to get everybody at the closing table to sell a piece of real estate as they had to in the older days. Now, having mentioned the Uniform Partnership Act, I want to talk a little bit about statutes and statutory law and how they work. As I said, the common law definitions, the ideas, the concepts all arose through the courts to tell us what partnerships are, what they mean, how they operate. But in the 20th century, the legislatures of the various states felt compelled to not leave that on its own, to not let that be separate by itself, but to begin to pass statutes to regulate and control partnerships, and particularly to control their activities towards third parties. So they began to pass statutes. Now, again, for those of you who haven't had a lot of law before, a statute is a law that's created by legislation that goes either through a state legislature or through Congress. And once it passes, and usually in most states it has to be signed by the governor, on the federal level it has to be signed by the president, it then becomes a law, and we now stick it in the law books wherever we think it is most appropriate for it to go. As statutory law, another concept that has developed over the years and became very popular in the 20th century and popular in the states out west that were newer and didn't have hundreds of years of laws and legislation passed, is the idea of a code. When you write a code, you're trying to take a specific area of law, such as partnerships or corporations or probate law, and write a set of statutes that apply specifically to that area of law and that try to be comprehensive, try to cover everything involved in that area of law, and you try to set it out in an organized way so that the Uniform Partnership Act would begin with, here's a definition of a partnership. Here's how you form a partnership. Here are the duties of a partner. Here are the rights of a partner. Here is how the management of a partnership will be carried out. Here is how partnerships will deal with third parties. Here is how a partnership will be ended, terminated, dissolved. So you try and lay out a scheme that is easily reviewable on its face. People are able to look at it, figure out what's going on with it. If you look at the laws of Rhode Island, Massachusetts, Delaware, New York, some of the older states that have been here for going on 400 years, it gets very confusing at times. The laws overlap. They don't always make sense. You can't always find them in the section of statute books where in modern ideology or modern thought we think they would apply, would show up. So there has been, beginning in the 1940s and moving forward, there has been a movement. Groups of law professors, practicing lawyers, and judges in various areas of the law have gotten together, formed committees, and have started working on what they call uniform laws. One of the earliest and most important of these is the Uniform Commercial Code. If you have taken the contracts course, you have encountered the Uniform Commercial Code because it now regulates all buying and selling of goods. All contracts for the buying and selling of things, which make up the vast bulk of our economy, are controlled by the Uniform Commercial Code. It has been passed by 49 states, and what it does for a lawyer who's representing business people involved in commerce is that it lets you know that with only very minor differences, the law is the same in Massachusetts, Rhode Island, California, Nevada, Oregon, Florida. If you have a client who's doing business in one state, selling products to another state, but they have to travel across 5 states to get to the destination state, You no longer have to look at the law of 7 jurisdictions. You know what is happening from the point where that product is manufactured, leaves its home state, all the way through to finally getting to its destination, to the consumer or the customer. So uniform acts have become more and more popular. Each state legislature must look at these. They must pass them on their own. There is no federal law that says, oh, we are now requiring you states to have a uniform this or a uniform that. And Massachusetts and Rhode Island have both passed the Uniform Partnership Act. So now partnerships in both those states are controlled by this statute. They're no longer under the common law exclusively. And this brings us in line with most of the other states in the country. In Rhode Island, you would look at Rhode Island General Laws Title 7, Chapter 12. And in Massachusetts, you would look at Mass General Laws, Title 15, Chapter 108, to find each of our states' versions of the Uniform Partnership Act. Okay. There really are few federal rules, federal laws about partnerships. Partnerships are, by and large, state entities, and they are governed and controlled by state law. However, as with everybody and everything in this country, partnerships have to deal with federal taxation. And even there, the federal government and the IRS, since its inception in the 19-teens, has looked at partnerships almost from a common law perspective. Partnerships are not taxed as the partnership. They are taxed as the individual partners. Now, there are such things as partnership returns, which are basically duplications of the ledgers of the partnership for a year, showing how much money came in, how much was spent on business expenses, and then whatever is left, if there is money left, is called a profit. That profit is divided among the partners according to the partnership agreement. If there is no agreement, it's divided equally. And for federal purposes, whatever profits are on the partnership books at the end of their tax year become the income of the individual partners. They must declare that on their individual income tax statements, and they pay taxes on it as if they were individual earnings from wages or from interest or from rents or other operations of a business like a sole proprietorship. The good thing in this is that they are only taxed singly instead of doubly. And we talked a little bit in the last chapters when we were talking about sole proprietorships that one of the advantages of a sole proprietorship to some corporations is that there are many types of corporations that are doubly taxed. The corporation closes its books for the years. If the federal government sees that there is an accounting balance there is money, then the government swoops in and takes out a corporate tax. That corporate tax is eventually distributed out to the shareholders, and the federal government comes running in again to each of the shareholders and taxes their distribution as a individual income to them. So with very many types of corporations, there's basically double taxation going on by the federal government. That is not true of sole proprietorships, and it is not true at partnerships, even though under the Uniform Partnership Act, a partnership is under law now a separate, distinct entity from its partners. Now, to form or create a partnership, ideally, you will go to see an attorney, or you'll get online and you'll educate yourselves legally, and you will come up with either a partnership agreement, or with those types of partnerships that have to be registered with the Secretary of State, you would come up with articles of partnership. And these documents would set out the relationship of the parties. They would set out the nature of the partnership, the purpose of the partnership, what activities were allowed by the partnership. Can be very important for determining legal rights, liabilities, responsibilities, duties. However, as we learned in the Deguano case, our first brief, partnerships are not always formed that way. The law, again, harking back to the common law days, they will look at the de facto, the true fact, on the ground situation, and if it looks like a partnership, quacks like a partnership, walks like a partnership, does things like a partnership, pays out its income like a partnership, then the law has no problem saying that there was an implied partnership here, even though the parties involved never called themselves partners, even though they did not want to be considered partners. If they were running some type of business operation for profit and it looks like a partnership, and particularly when it comes to upholding the rights of third parties or recovering damages for third parties, the courts have no problem saying you had an implied partnership. We don't care if that word never entered your head. You were operating and acting together in this business adventure, and that made you a partnership. Now, that becomes critically important because, as we said, every partner is the agent of another partner, all the other partners, and of the partnership. So every partner now becomes responsible for everybody else's actions who are operating in the partnership. And in terms of contractual and tort liability, every partner is deemed to be vicariously liable for the activities and the debts of all other partners. This is one of the critical distinctions between a partnership and a corporation. Of course, as we get into corporations, we'll go into that more fully, but just realize that in a regular partnership, a regular business partnership, or sometimes called a general partnership, every partner is responsible for the bills, for the debts of the partnership, and every partner is responsible for the torts and breach of contract liabilities. So if when the partnership fails and now is being sued for money, if three of the partners are broke and bankrupt, but one of them has $10 million in his personal portfolio, his personal assets, then that one partner can end up being sued to make good on the bills and the debts and the liabilities of all four of them. A very, very sobering thought. Be very careful with who you go into partnership with, and really to escape these types of liabilities, to protect your personal assets from the operation of your business, you really need to have an attorney involved in setting things up for you and explaining to you how these things should happen. Partners can have agents who are not partners. They can hire people to go out and make agreements, make contracts, do deals on behalf of the partnership without making them partners. They can have employees so that they can hire people to do work for the partnership. And very often with larger partnerships, this is exactly what happens. Estoppel. Going back to the idea that there can be an implied partnership. Even if you didn't call yourselves partners, even if you didn't have a partnership agreement, if you were conducting your business in a way that would lead a third person to believe it was a partnership, then you can be stopped from denying there was a partnership in any litigation brought against you. Remember, we talked about this a little bit a couple of chapters back. Estoppel is this legal contract which says that you will not be able, because of technicalities, to plead something that the facts show to be obviously not true. So again, if you're acting, operating, splitting profits, splitting responsibilities and liabilities as if you were partners, when a third party comes along looking to sue anybody and everybody, you're going to be stopped from claiming in your complaint that, or your answer that, oh, we weren't a partnership, Your Honor. There was no partnership here. The court will look at the facts, and if they believe that the facts indicate a partnership was or could be present, they will prevent you from arguing or even bringing in evidence to disprove that. So just realize that with the idea of implied partnerships is this idea of estoppel, that you may not be allowed to deny a partnership if you are acting like partners. Now, rights of partners. The principal right that they have is to manage the business, to be part and parcel of the control and running of the business. Normally, if there's nothing else in writing, this is done by majority vote. However, if you have a partnership agreement or you have articles of partnership, this can be altered by the terms of the agreement. I know when I was a young attorney, I worked for several law firms that were in those days still traditional partnerships, but they had very complicated partnership schemes so that there were associates who were basically nothing more than employees or hired agents. Then you had junior partners who shared something in the profits of the corporation but had no right to vote or control or to regulate. There were managing partners who had control over how the partnership would be run and what activities it would conduct. And then sometimes there would be senior partners who, by definition, not only had the right to control and manage, but got a superior percentage of the profits that were brought in any given year by the partnership. So the profits were not they were not divided equally among all the partners, but they actually set up a tier system so that when you started as a junior partner, you got a very tiny percentage of the profits, whereas if you were a senior partner, you were getting a very large percentage of the partnership profits at any given year. So all of that can be regulated by your agreements, but if you have no agreement, the default presumption under the law is that everything is equal. Management and control is equal, and sharing of the partnership profits are equal. Now, under the common law and under the Uniform Partnership Act, certain activities of the partnership can only be conducted if a unanimous decision of all partners is made, so that 2 or 3 partners can't vote against a fourth partner and say, well, we're going to go do this even though it might ruin the partnership and you have no say, you're a minority. There is a list of things that the law says all partners must be in unanimous agreement or the partnership cannot go into these areas. Now, these various things fall into, number 1, altering the nature of the partnership itself can only be done by a unanimous decision. Changing the capital structure, which means if we were to break up, how much of the assets would go to each partner. And again, that can be established at the beginning by agreement. In order to alter that agreement, it must be done by unanimous decision. Amending the agreement itself must be done by unanimous decision. Bringing in new partners. There are 4 partners now. 3 people want to bring in this new woman, thinks she'd be really good and be able to up their profits in that. The present partner disagrees. You cannot bring in a new partner unless there is unanimous agreement. You cannot engage in a new business, entirely different. Now, a majority of the partners may be able to agree that we're going to engage in a new business venture, something that's already in the field that we work in, but is a new client, a new thing that we're doing. But if we are selling automobiles as a partnership and now somebody decides, let's go and be real estate agents and sell real estate, that would require unanimous consent because you're moving the partnership into a whole new business area. To assign assets, to basically pledge assets as security for debt, or to confess to judgment, which does not exist in Rhode Island and Massachusetts, but in some states, in order to borrow money, in order to buy goods on credit, you have to sign a document that's called a confession of judgment, which basically means you've agreed to lose in court before you even begin. So if you don't make payment, the creditor can run down right to the courthouse, file this concession of judgment, and now they have the long arm of the law, they have contempt proceedings, they have the constables and the sheriffs to go chasing you for money. You cannot do that in a partnership in the states where that is allowed without unanimous consent. You cannot dispose of the goodwill. Goodwill is a somewhat difficult concept. Putting value on goodwill is an extremely difficult concept. I have to say, after 40 years of being in business and dealing with business clients, I still somewhat hesitate when people start talking about trying to value goodwill. Goodwill is the perception of a business that has been built up in the community over time, and that community can be local community, it could be the community of people that buy and sell this product on the web, it could mean within the community of other people involved in this business on a regional basis, on a countrywide basis, even on a worldwide basis. Goodwill is this idea that you have been in business, people understand that you're reputable, you're fair, you have a good work product or a good product, and basically you have positive perception throughout the world where you have to wheel and deal to make your contracts and earn your money. And goodwill is quantifiable to a certain extent. Accountants work very hard at putting numbers on this. And when my clients are buying and selling businesses, the buying and selling of the goodwill associated with the name of that business is something that is part and parcel of the negotiations, and also part and parcel of the purchase and sales agreements. And very often, people will want to keep the name of a business, even though it might be somebody else's family name or not at all associated with the new buyers, again, because that name has a certain cachet of goodwill that has been built up over the years, and that's basically advertising that you can't buy at any price. If you open up as a brand new business and you have to start working your way into the marketplace and getting people to look at you and pay attention to you, anyone who's done that can tell you that it's a very expensive and difficult and frustrating process, and that many business people, the majority of business people actually that start out, fail at that and the businesses fold. So being able to buy the reputation, buy the name, buy the sense of fair play and security that people have from dealing with this company is an important aspect. So getting back to our topic here, one partner or the minority group of partners or even a majority group of partners cannot transfer or sell the goodwill of the partnership without unanimous consent of all. Okay. Arbitration is a system. It's an idea where instead of spending all the time and money to go to court, to go through the procedures of discovery, of filing answers and complaints and motions and interrogatories, depositions, that instead we submit our dispute to an arbitrator or an arbiter. We agree to arbitration, which means that we set up a person or a group of people to hear both sides of this issue, to study it, to look at the facts, and then to make a decision as if they were a judge and jury in a court. Now, many contracts have arbitration clauses in them, which say that, particularly if you're dealing with big companies, that say that if there is a dispute, you waive your rights to go to court, you agree to arbitration. These clauses cannot be buried in the contracts. They must be clearly visible, and they must be agreed to as separate and apart of the regular and other consideration and back and forth that's going on in terms of the contract. So, in a partnership, if there is a claim, if there is a contest, if there is something that looks like it's going to end up in court, and it was not already by terms of the agreement where it exists submitted to arbitration, in order to take that claim that could be tried in regular court and submit it to arbitration requires unanimous consent. Right, and then finally, any action that would make it impossible for the business to continue cannot be taken by one partner alone. It must, or even by a majority group of partners, it must be consented to unanimously. Now, still under rights of partners, this first discussion we've had for the last few minutes is all about the management. All partners have a right to share in the management. All partners have an interest in the partnership. They're a part owner of whatever equity, whatever value, whatever assets the partnership have, and they have a certain right to get the profits of the partnership. If they don't have ownership and they don't have rights to participate in profits, they may be an agent, they may be an employee, they may be something else, they are not a partner. So by definition, even under the Uniform Partnership Code, a partner has a certain ownership right in the assets of the partnership, and they have the right to claim a certain amount of income from the partnership. Anyone who's affiliated with this entity who does not have those rights is not a partner. Now, compensation. Not only do partners receive part of the profits of the corporation when they close the books at the end of the year, but they also have the right to be paid for their work, for their skill, for time that they've given to the partnership. And this can be by way of salary, it can be by way of hourly wages, it can be by way of an additional sharing of the profits above whatever other mechanism there is for dividing the profits. Um, Partners have a right to be paid for the activities that they put into the partnership. They also have the right to reimbursement. So if they expend money on the partnership, buying things, putting gas in their car to travel to business meetings, whatever equipment they might have to buy to carry on the partnership dealing, the cell phone charges they use in carrying on partnership business. You can go on and on and on thinking about it. They have a right to be reimbursed for those items that they have expended on behalf of the partnership. Every partner has a right to inspect the books. All right? The whole sense of the partnership is that you are a part owner, you have control, and as part of that control, you also have the right to receive profits and to determine what profits you should receive and to tell if you're receiving your fair share. You have a right to inspect the books. The Uniform Probate Code covers up what was a big hole in the common law and also says that personal representatives of a deceased partner have the right to examine the books. Under the common law, once a partner died, the partnership was dissolved, it was over, and because it was dissolved, if the remaining people decided to go on, they were forming a new partnership, and the common law held that the family members, the executors, administrators of the new partnership, in many cases had no right to examine the books to see what happened, to see if they were still owed any money to the estate of the deceased partner. The Uniform Probate Code makes it clear that personal representatives of a deceased partner, and I would assume that would apply to a guardian of a disabled partner, have the right to inspect the books as if they were the partner themselves. There is a right to an accounting of assets and profits. So every partner, no matter how they're involved, has a right to demand an accounting of the books, a summing up of what's going on here. What is the total? What are all the assets? What is their total value? What are the profits that were made in the last period, that we count, and to have that laid out to them. Now, property rights. Property rights in partnerships are a little bit different than a regular thing. Under today's law, partnership property can be held in the name of the partnership itself. You don't have to put it in the name of the individual partners as we had to at common law. And it includes two things. Very often in a partnership, what happens at the beginning is everybody puts in a sum of money to get things going, and those sums can be equal or they could be unequal. And they are added to the books as part of a partnership's interest, partner's interest, but once you give them, they belong to the partnership. Certainly any property, any goods, any equipment that are acquired after the partnership is set up in the partnership name belong to the partnership. They do not belong to the individual partners. The individual partners cannot separately sell them, nor can they be taken and sold for the debts of one partner. However, they can be attached, which means that you can go to court if one partner is being sued by you and you get a judgment against that one partner for, let's say, something that happened in his personal life, not in the partnership business. You cannot grab partnership assets. However, you can take your judgment, turn it into what's called a charging order, and file it as a lien against the partnerships or against the partners portion of the partnership. And eventually, if the partners want to borrow more money, the bank is going to want that cleared off and taken care of. And if the partnership in some way dissolves, you can get your share of the sued partner's assets from that, or you can make a claim saying that whenever profits are to be paid to this partner who had lost a lawsuit, that those profits have to be sent out to satisfy the judgment and not go directly to the partner. Okay, duties and liabilities of partners. Every partner, as we said, is a general agent of the whole partnership and of every other partner. Every act of a partner in furtherance of the partnership business can bind the partnership as a whole. So every partner acting individually has the potential right to create contractual liabilities for the whole partnership. Now, partners have a fiduciary duty to each other. And we spoke about fiduciaries a little bit in the past, and we'll continue to speak about them as we meet them at different times. A fiduciary is someone who handles assets and property on the behalf of another. And in doing so, they have to put the well-being and the good of the other ahead of their own good. They have to allow the other to profit first, to benefit first, and they are not allowed to put their interests before the interests of the person who they are working for as a fiduciary. Every partner is a fiduciary to the other partners in the partnership. So every partner has the duty to work first and foremost for the partnership, to make sure the partnership interests are ahead of their personal interests, and they cannot waive this duty, even by a partnership agreement. So under the common law and under the Uniform Probate Code, a partner must behave in a fiduciary capacity towards a partnership, towards the other partners, and they can't. And an example of a violation of this would be a partner is able to negotiate a $1 million deal with some company to buy partnership goods. But as part of the negotiations, that partner says, well, okay, I'll work with you guys. We'll get this $1 million deal set up. But in order for me to pass it by my other partners and to really push it and make them want to go along with it, I want you to give me $50,000, hire me for 2 weeks as a consultant, and we'll do the $1 million deal with the partnership, and you'll give me a $50,000 consultant fee. Because the partner, and it's nothing particularly illegal about that. There are many people who act as factors and who act as independent agents in business, trying to put together business deals, and they get paid a fee. In the past couple of years, I've had large commercial clients looking to borrow money, and they basically hire a money finder. They hire an agent to go out and to troll all the different types of banks and insurance companies and brokerage companies and other places that loan money to commercial ventures. And once they have found a lender that's willing to deal with my client, they get paid a finder's fee for doing that. It's basically a consultant fee for helping my client weed through all the thousands of possible lenders out there and hopefully not have to get denied 9,999 times before they find the one who would actually loan them money and give them the money that they're looking to borrow. So these things are not illegal. However, as a partner, you were to do the scenario that I spoke about and say, well, I'll help you guys get into this partnership deal. I'll really push it and sell it with my other partners. I think it's good for us. It'll be good for you. But you have to say that I was a consultant on this and I get paid $50,000 apart from that contract. The law says that that is a violation of fiduciary duty and that $50,000 should actually go to the partnership to be shared by all. It cannot be held only by that one partner, because in that case he was putting his own interest before, or at least parallel with, the partnership interest, and he was basically trying to get a cut of his own on the side and cut his partners out of that part of it.